Prior to joining Nexa, I headed up the wills and probate team of a East Midlands law firm. I regularly appear on BBC Radio Leicester now, so what I don't know about wills and probate is probably not worth knowing in theory, but I'm sure there's plenty out there I don't know about.
That's good. So this is what we're going to cover today. Hopefully everybody knows the agenda, but just to cover it off very briefly. So I'm going to be looking at staff layoffs and redundancies, including something about the coronavirus funding, some insurance issues, what you might have and what you might want to have in place. Sam's then going to deal with business power of attorneys and what happens if you can't make a decision. She's also looking at business legacy planning with wills and trusts, that kind of thing. And then back to me and talking about getting a shareholders agreement in place, why that's important, and the importance of terms and conditions. And then after that, we'll have some questions. So firstly, then, employment issues. So this is obviously the big topic right now, and we're seeing, and I've been inundated with questions about it, and as most accountants have as well. What is this scheme all about? So I'll come on to that, but first of all, up until the allowing of employees, there was a couple of options that companies had, and those options still exist. So in times that are tough, you can lay off employees. So laying off an employee is asking them to stay at home or take unpaid leave if there's not enough work. And what the law says, if they are laid off for more than 4 weeks, that they are entitled to claim redundancy pay because they're in a position where there clearly isn't a job available for them. But the problem with laying off employees is that the company doesn't have to pay them anything, and employees only get their guarantee pay provided by the government of £29 a day. Because they're still at that point technically employed, so they're not able to claim benefits, universal credit, so they only get the guarantee pay. So that wasn't an ideal situation. The other alternative that businesses have, and some businesses already did this preemptively, was redundancy. And redundancy is a process where there's a business or workplace closure, or what the law calls diminished requirements for that kind of work to be done. And so ordinarily, if we didn't have the coronavirus and the whole the panic that is going around it, there'd be a lot of businesses in a recession time looking at redundancies. The problem with redundancies is there's a process to go through. You need to be sitting down with the employees. You need to be consulting with them. You need to be trying to find them alternative work or alternative roles. And ultimately, in a redundancy process, you still need to pay people their contractual notice pay, which if you've got somebody that's been there for a long time, that could be quite expensive. You need to pay their holiday pay that they've not taken, and you need to pay them redundancy pay, which is based upon how long they've been there and also based upon their age. So redundancy as an option isn't great where the cash has just stopped, which is what we've seen now, lockdown and that kind of thing. Cash just stopped for businesses. So redundancy really wasn't too much of an option either. Which is why the government introduced this new concept of allowing workers, using terminology which I understand is from horses and nothing else. It's not been anything that any employment lawyer has ever come across before. We've never heard the phrase. It's not been used in courts, case law, or legislation at all, or anything like that. So it's a completely new concept. And one of the problems that we're facing is that there's just a lack of guidance. So it was announced by the Chancellor that this is what's going to happen. The problem is everybody seems to think that that's going to happen immediately. And what seems to be the case is that actually this is going to be rolled out probably, by the sounds of it, late April, early May. And that puts people in a position. So I know a lot of clients already have sought an agreement, let's say in inverted commas, with their employees to allow them. And it is important that you get an agreement, because if you don't, then it's technically in breach of contract. But it seems to me what some companies are doing, and there's a real risk here, is some companies are assuming that the government has already paid them the 80%, and therefore this month's payroll, they're only paying the 20%, top-up pay. And I think there's a real risk with that for a couple of reasons. Number one, you are immediately in breach of contract, fundamentally because you've not paid your employee, sorry, which gives them a right or entitlement to turn around and say, do you know what, I'm not coming back to work, right? And that's the end of that. Two, they could bring a claim against you as a business for that unpaid. And three, and perhaps most importantly, knowing how governments work and HMRC work, it's a grant. We know it's a grant, it's not a loan. It's a grant. It's going to be based upon reimbursement. And therefore, you'll need to be able to demonstrate that you've paid the money to your employees to be able to claim that back. That's my view. It's not written down. At the minute, there's no guidance there, but that's that. What we do know about the scheme, as it's been touted at the moment, is of course that the government are going to be giving a grant for 80% of an employee's salary, backdated to the beginning of March. And I suspect because of real-time information on payroll submissions that they'll know what your employees are entitled to. And so there's no kind of fraud or scamming the system and saying, well, I pay all of my employees, that's exactly the $2,500 that we're allowed. So that's that. The other issue that seems to be up in the air at the moment is whether or not sole director companies can allow themselves to effectively claim the 80% of their own wages. My view on that is no, they can't. So if you've got a husband and wife company and you're paying your wife or partner, whichever way, as an employee, then certainly you'll be able to allow that person, your partner, and claim that grant for them. But as a director of the business, my view, unless there's some guidance or legislation that comes in place that changes this, my view is that you're not going to be able to do that for yourself, because you can't, as a company, make the decision to unfallow yourself at some point. Because if you're no longer an employee, you can't be the director, and the company always needs a director in law under the Companies Act. So my view on it is going to be that directors aren't going to be able to do it. James has shared the link for the ICAEW, which has got some good guidance on there. They seem to suggest that it will be available for sole directorships, but no, James is nodding. But again, my view is that it's not. There is case law to support my view, not on the scheme itself, but on whether or not a director can make himself redundant. So when we're looking at employment and employment practices, it's about getting your business fit for future. And as I say, it's thinking about the spring. So taking this opportunity to make sure your contracts of employment and your staff handbooks are as good as they can be. Making sure that we have all the policies in place that we need. So one of the things that clients always say, and people generally say, is that employment law is a minefield. But it isn't, and absolutely isn't. And it's not that I'm not saying that because I have 12 years experience in dealing with it. It's not, because all it is processes. And if you've got processes in place, then all you need to do is follow them. And so all you need to do is have processes in place. And that's that. And also, look, don't be a racist or a bigot or something like that, because if you discriminate against somebody, I can't help you. But for general terms, if you've got a handbook that has processes in place, then whatever the issue, as long as you follow that, you won't have any claims against you. So it's really important to take this time to sort of plan that and think about your employment contracts. Insurance, then, moving on to the next slide. Insurance is something that is also a bit of a hot topic at the moment, because there seems to have been a lot of people think that they've got insurances, particularly in the hospitality industry, insurance for known as business protection insurance, or loss of business, loss of profit, that kind of wording. And I think there's been a few people that have been disappointed that they've had to shut their shop and then not be able to claim, and thinking that they might have coverage. So there's a whole raft of issues. I've just written an article for a national newspaper about it. But in short, basically, generally speaking, this kind of insurance is attached to the buildings insurance, and so it only kicks in if there's a claim against the property, i.e. damage, i.e. a fire, or burning down, explosion, that kind of thing. You can't trade from that property anymore, and therefore there's loss of profit that kicks in. So that's the usual situation. Also applies to landlords. So I had a client that thought that they had loss of rent cover on their insurance. but it only kicks in if there's damage to the building. This isn't just something if the tenant doesn't pay. Now on tenancies, some people do have loss of rent insurance that's, you know, bought through a letting agent or something like that. That's a different thing. And that happens if the tenant doesn't pay the rent. And I've not had a look at that. I don't know if that pays out or not. Some people do have standalone insurance for it, and then that depends on what the terms of the policy say. So I've had a couple of clients email me with different policies. One of them said it had cover for what's called a notifiable disease, and some of them just said, you know, human contagious diseases, that kind of thing. So again, it's always really important to have a look at your insurance. And the one thing that I say on insurance generally is I am not an insurance broker. I am not the person to speak to about insurance, but you should speak to an independent ABI insurance approved FCA regulated person that can give you advice on exactly what you need and explain it. But when we're looking at businesses and planning for spring, planning for that growth, then now's the time to start thinking about what insurances you should have in place. So one of the things that I always recommend to clients when I'm advising them is looking at key man insurance, the term that most people understand and know. That's insurance that's taken out on the directors, on names, and putting that in place with a cross-option agreement, which means that I take out insurance on someone else's life, they take out insurance on my life, and then if one dies, I get the money and I can buy that person's shares. And that is usually a good way of doing it, depending on your circumstances, but we'll talk about it on shareholders agreements and business planning with Sam, is that what tends to happen is when somebody dies, you don't necessarily want your estate, your personal representative, your partner or whatever, to have your shares. You'd much rather have them have, you know, a lump of cash. And so having that insurance in place to make sure that the other party, the other shareholder or director in the business has got that money seems to make sense to me. So that's that. Right, over to Sam. She's going to talk about powers of attorney for you and in particular your business.
Okay, thank you. So, lasting powers of attorney. First of all, what is it? So it's a document where it gives somebody of your choosing power to deal with all of your financial affairs and assets. So quite often you will find that you'll have your personal affairs and assets that need to be managed, and then you'll also have your business affairs and assets. And depending upon your circumstances, you might not want the same people managing both your personal affairs and your business affairs. So generally, in terms of when they're used, tends to be when you lose capacity. So it can, though, be used when you've still got capacity. So you might be poorly and in hospital. You might decide to go on holiday, and it's happening at the moment. For example, you might end up going to Peru and get stuck there due to the coronavirus or whatever it might be. So it's not only useful for when you've lost capacity, it can be much wider than that. Now, what can your attorneys do? So basically anything that you can do, your attorneys can do with your assets and financial affairs, but in particular in regards to your business. They can use the LPA to pay your suppliers, to pay your employees, to pay your tax, for example, and probably more importantly, to get money coming into the business, which is probably what you're most bothered about. Now, what happens if you don't have a lasting power of attorney in place for your business? Well, ultimately, most of your accounts will freeze. So as soon as your bank finds out you've lost capacity, then they'll freeze the account. They won't let you touch the contents, nor will they let your spouse touch the contents, for example. Quite rightly, because they're worried that then you're vulnerable. And so your spouse or whoever it is that wants to get access to your bank accounts might empty it and run off with the proceeds. So things get frozen, and then we begin a costly and lengthy court process in order to get somebody appointed to look after your financial affairs and assets. By which time, because it takes around about 6 to 12 months, by which time potentially your business has failed. So it's really important to get a lasting power of attorney put into place. In terms of what we need to know as solicitors, we'll need to know a little bit about your business and the background. We'll need to know its structure, whether it's sole trader, partnership, or limited company, or an LLP. And we'll need to know what type of business you're running in order to give you the best advice possible. Depending upon the structure will depend upon what our advice is. So if you're a sole trader, you should certainly have a lasting power of attorney. However, for partnerships and for limited companies, we will be wanting to look at your partnership agreement and your articles of association, as quite often, for example, in regards to articles of association, it will actually state within there, not always, so it needs checking, but often it will state that on the incapacity of a director, their directorship terminates. So in which case it's not quite so important to have an LPA in place in that case, but certainly for your personal finances instead. So we'll need to know quite a lot of information. Most importantly, think carefully about who you appoint. So you really need to trust that person. They're going to be able to do everything you can do. So you're going to be relying upon them, to either make your business a success, or potentially they're going to run it down into the ground, and you don't want the latter. So it needs to be somebody you trust, and it needs to be somebody with a little bit of business acumen, or somebody that knows your business or can quickly grapple your business and then proceed onwards. Okay.
Yeah, and I think for me, one of the things that is was really quite surprising, and we've probably all seen it, mostly on Facebook actually, posts where somebody's got ill with the coronavirus and they're very quickly escalates to them being taken away in an ambulance, going to hospital and then dying, and or at least being in hospital for a few days and or weeks, and that person can't see them. You can't go in and see them. You can't go and say, hi, this and this, right? Now, if you've got a business and you are the person that is making that decision, then you need to be able to have somebody in place to be able to do stuff. So we're talking about, making decisions, making payments, signing things off, etc., etc.
So important.
So I think that's that's important to just make sure that people know what they need to put in place. So, wills and trusts.
Wills and trusts. So obviously, there is going to come a time that we're all going to die. So to have a will, it will make sure that what you want to happen happens, subject to the possibility of any claims which I as your solicitor would deal with and advise you upon. So in terms of your business, you need to think about what you're deciding to do with it. What's the idea? Do you want it to continue operating? Do you want to sell it? Or will you liquidate it? In amongst that, obviously, your business has got a value. So in terms of the value of it, that will be added into your estate for inheritance tax purposes. Depending upon the business, you might get business property relief. And if you do get business property relief, then you need really good advice. What we like to do is to retain that business property relief. We don't want to waste it by you giving everything to your spouse and using the spouse exception. So in order to do so, what we like to do is use a trust within your will. And that will ensure that you've got all of your spouse exemption and you keep your business property relief in there as well. So we're maximising the amount of money you keep in your estate, and we're minimising the tax. So again, very important to get into place. Shall I let you continue with your part, Steve? I've not covered shareholders agreements and cross-option insurance just because you've mentioned it already. And I know you're about to talk about shareholders agreements, so I've cheated.
Yeah. So again, all this is remembering, just focusing that when we're in the winter, when we're in the downtime, it's the right time to start planning for the growth. And a shareholders agreement is something that every business should have. They should have really at the start of setting up a company. If you're going in business with one or more people, you should have a shareholders agreement, but most people don't. But it is important for future planning and growth. And if you've got a desire to grow and indeed an exit plan, and you're taking advantage of the opportunity, then having a shareholders agreement in place is really good. And particularly for this, right? So it's important for future planning in terms of what happens to the shares when you die. So if you don't have a shareholders agreement in place and the articles don't say anything, when you die, your shares will get inherited either through your will or through the rules of intestacy if you've not got a will. So that could be your shares being inherited by your partner or your kids, or if you don't have any of those, your brother, or if you don't have any siblings, could be your mum and dad or your auntie, whoever, right? And then they potentially have control of the business and the company. And so lots of people say to me, I've sat with lots of clients, they'll say, oh, we don't need a shareholders agreement. We're all friends, we get on. We know what's going to happen. Yeah, well, okay. So what happens if you die and then your wife's got the shares? Well, she would sell them to the, back to the other company, back to the other guys. Yeah, but what if she doesn't? What if actually secretly she's been harboring hidden agenda to make, that says, I know how to do this better than you. Now that I am a 50% shareholder, I'm going to start running this company. I'm going to turn up on Monday. I'm going to do X, Y, and Z, and really start running the show. Do you want that? And do the other guys want that? And do your original shareholders want that? Probably not. So having a shareholders agreement allows you and the original shareholders to dictate what happens on shares when somebody dies, or when they're made bankrupt, or those kind of things. So they're really important. And also really important for future growth and planning, and exit planning in particular. So if you're working a business with a view to growing it to exit planning for retirement, and you've got other shareholders, not just you on board, there could be employees, directors, minority shareholders, then what you want is a shareholders agreement that forces them to sell their shares at that time. Those things that are known as drag along and tag along options, preemption rights in agreements that say, okay, look, if somebody comes along and offers us £10 million for this business, and I'm a 40% shareholder, the majority shareholder, because I've got all these other people that are minority shareholders, I want to make sure that we sell. And so I want to take you and all of those shareholders and drag them along with me to make sure that we get the right price for this sale. Without that, then you've got a situation where you've got this great offer for this business that you've worked on for the last 10, 15, 20 years, and difficulty on whether or not you're going to sell. And you could have a minority shareholder going, well, I don't want to sell, I want to stay where I am. So shareholders agreements are really important in times of growth as well. And as I mentioned before, they also allow dispute mechanisms to be built in as well. So what happens if there is a dispute? If you've got a 50-50 shareholding, which is very, very normal, what happens if there's not an agreement in place? How does that get decided? And normally we refer it to an arbitrator or something like that. We're running out of time on this, so I'll just quickly skip over terms and conditions and contracts. So it's really important, I think, to get all of your legal paperwork sorted. So terms and conditions are really important, and this is for any business. The moment what's called force majeure clauses are under the microscope. These are the clauses that say, we can't perform this contract because of this act of God, in inverted commas, or some other reason, and therefore we're going to have to terminate the supply contract. So if you've got Primark, for instance, that have placed millions of pounds worth of orders of all their suppliers, they are now relying upon their force majeure clauses that say the environment says we're going to terminate, so we're terminating, and we've got no liability for the work that you've done so far. So really important to make sure that you've got good terms and conditions in place right now. So it's about looking at what contracts do you need now, what do you need to put in place for that growth, etc. Lots of businesses as well, they're adapting, of course. If you can, then great. So that people are looking at changing their business delivery models and making it online, doing face-to-face by video call, etc. Now that has its own problems, because if you're dealing with consumers remotely, i.e. not in your shop, not in your offices, then the distance selling regulations apply, and then they have a 14-day cooling off period. And what's really, really important about that is if you don't tell them they have a 14-day cooling off period, the 14-day period starts when you tell them. So if you never tell them, they always have the right to cancel. And that could be after you've done all the work. And if you've done all the work and then they turn around and cancel, you ain't getting paid. So really important to make sure that you've got all of those documents in place. And if you are doing work on an urgent basis for somebody, or they require it within a 14-day period, that they are waiving their rights, things like that. So it's about, look, changing the way you work also means changing some of the legal aspects that we're looking at, particularly the terms and conditions. So look, I've gone through that reasonably rapidly. And now if I unmute everybody, don't shout all at once. Any questions, then we can answer them. Unmute all. So one at a time, if you've got any questions, but shout up and I'll try my best to answer, or Sam will try your best.
Hello, can you hear me?
Yes.
Oh, hi, Barry Stephen here. I wondered, thank you very much, both of you. It's been really interesting. I just wanted to go back to the point you made earlier with regards to directors.
Yes.
So me and my business partner, Jochen, who's on this group, I just want to clarify the self-employed issue around the directorship. So
yeah.
what does that look like in terms of being able to claim?
Okay, so if you're a director of business and you need to carry on being a director of the business to make business
decisions,
making decisions, you can't allow yourself. You can.
Right.
The business is always going to need one director there. Now you can do it with other directors. You know, if the business is in.
So I can allow Jochen, could I?
Yeah, exactly. Yeah, and the decision-making process there is then probably either subject to any shareholders agreement that you've got in place, you know, that says who can make decisions. If there's only two of you, you know, how do you make the decision? But yeah, you couldn't fill out every director. There needs to be at least one still on the books.
You know, absolutely. But I mean, what would be the benefit of allowing Jochen anyway? I mean, what I'm trying to get to is to establish whether I'm entitled to a benefit, a claim from, you know, as today he's going to announce the self-employment.